matter of par on the application of rights to Community Action Ltd, the Secretary of State for Living Up, Housing and Communities.
Miss Westwood.
A couple of small points of housekeeping. Firstly, I've put on the bench an authority that's referred to by the Secretary of State and the OEP, so it's largely for completeness. I'll come to it briefly when I list some authorities later. It's the Equalities and Human Rights Commission. For reference, it's para 50 of our skeleton, para 36 of the OEP's skeleton, but I wouldn't comment too much. The other point is a small one. It's mopping up a question that my Lord Justice Lewis asked yesterday of Mr. Goodman about having regard to the legislative history insofar as the fact that something was introduced by amendment. Mr. Goodman gave a tentative answer that he thought that probably was permissible. I've done as a little work as just pick up a copy of Cray's on legislation, and that endorses that position. So I'm looking at, for note of assistance, para 2751 of Cray's, which says that effectively you can look at the legislative or parliamentary history of a provision to illuminate its context. So you can I think that's fine. It adds a note of caution. Don't put too much weight on it. It goes on to look at a case where there'd been a withdrawn amendment that had been looked at, and it says we've got to be a bit careful with that. We're not, in this case, of course, we're looking at an amendment.
In addition to clause 1, yes.
That then leads me to submissions. I intend to start with a short observation on the Office for the Speaker's Council's letter, then deal with factual background, then ground 1, then ground 2. I'll take most of the morning, I'd expect, but I'll see how I do.
Thank you.
If there's points where,
Of course.
Where your lordships want me to expand or speed up, I'll take cues as appropriate.
Thank you.
So on the question about a written ministerial statement, so this arises from the letter of the Office of the Speaker's Council 2 days ago. The Secretary of State aligns himself to that. That's our position too. It's clear that relief cannot be granted to quash or directly declare unlawful a written ministerial statement because of WMS is part of proceedings in Parliament. The issue though is only one of remedy. It's the direct quashing, and given that the appellant's confirmed, I think, that it does not seek anything direct, it's the underlying decision that is challenging, and if we do get to the stage of relief, that's the relief that it would seek. The issue doesn't arise.
Well,
I note in passing,
do you quash the decision to make the ministerial statement? Do you quash the policy brackets as is described in the ministerial statement? They can't be right that governments can get out of judicial review by saying it and saying it only to Parliament.
Precisely, and I think that would be it's what can't, on the one hand, what can't be right is that the court can strike out and quash something that is a proceeding in Parliament. On the other hand, what can't be right is that government policy cannot be challenged. Yeah. There'll always be, where there's a written ministerial statement, a decision which is evidenced by the written ministerial statement. So that's.
Well, in a lot of written ministerial statements, they then form part of published guidance, which could then be quashed. Yeah. But this didn't. Is that right?
That's right.
It was going to end up as PPG according to a statement, but I've not been able to find it.
That's not happened. I think partly because of the change of government, there's that one's gone into the long grass, as it were. But it's not uncommon to have the only evidence of the policy decision being a written ministerial statement. And I think there was a recent case, Council Action Network, before some of the same constitution as this case, where what was challenged was set out in a WMS. So it's the decision behind it.
The decision to adopt the
and the policy itself, actually. I mean, they shouldn't be. If the policy is unlawful, it can't be insulated. There are. I mean, Miller was a case where something that arguably had happened in Parliament was actually quashed because the prorogation took place when 3 commissioners sat on the Royal Sack in the House of Lords. But I don't think we need to go there, so long as the government isn't trying to say it can't be quashed if it's acted unlawfully.
I think. I mean, there's a fair number of cases where there's been discussion of this. I think it's probably been said in a recent case, the Heathrow Hub case, that this is a matter on which perhaps fuller submissions could be given, i.e. the precise overlap between WMSs and judicial reviews. But we don't need to go there in this case, and for that reason...
well, it's plain the obvious for Speaker's Counsel, which properly polices these boundaries, is content with the proposed approach.
There's one small subsidiary point, which is one reason I go to this. There is a reference, an inapposite reference in my skeleton, that's paragraph 6 of my Court of Appeal skeleton, to quashing the WMS. The bottom of page 28 of the core bundle.
Yeah.
And that's not apposite, as I say, so I'll just ask the court to add in the word "the decision to make the policy in the WMS" or something to like effect there. So my first point is some factual issues or factual matters. It's critical to understand the nature of the policy instrument at issue here, and I make 7 points in relation to the nature of the policy instrument and what happened on the facts. First point, the Written Ministerial Statement is just one part of a wider policy package. It cannot be understood in isolation from that policy package, and that's clear from the Written Ministerial Statement itself. You've got that in the core bundle, page 304. And your Lordship sort of picked up in the third paragraph there, about halfway down the page, reference to a further change to energy efficiency building regulations planned for 2025, meaning the homes built to that standard will be net zero ready. This is the meeting of the 2019 climate change order. That planned change is the planned building regulations referred to in the WMS. The point that was made in the High Court and picked up early on in her judgment by Mr. Justice Lieven. And that underscores the close connection between the two policies. That's something that was recognised by the judge at paragraph 17 and paragraph 50 of her judgment.
Paragraph 17 and 50, did you say?
17 and 50, correct.
Yeah, thank you.
The second point, separate but similar, is that the Written Ministerial Statement on the challenge is transitional policy. It's intended, as is clear from the evidence, as a stepping stone to the Future Homes Standard. And we can get that from Mr. Palmer's witness statement at paragraphs 10 and paragraph 13. That's supplementary bundle page 53 to 54. In other words, and in the context of the previous judicial review brought by the same claimant, it was necessitated to fill a gap, and it fills that gap between the then, this December 2023, and the Future Home Standard.
It's not so much a gap, as I understand the policy documents, the contemporaneous documents, they say we don't think it's prudent to expect the industry to change to the FHS in one go. Therefore, we will have a staged or phased approach to the change, the uplift. It's not a gap as such, it's deliberately phased.
It's to smooth the transition. Yeah. If one didn't do anything, there would be a gap. Perhaps there's another way of phrasing it, but it's to, and in that sense, my lord, it is to support and therefore is integral to the smooth transition to the Future Home Standard. So it's part of the policy direction which the Future Home Standard will represent. The third point, and this can also be seen from Mr. Palmer's witness statement, the reference there is his paragraph 30 on page supplementary bundle, page 58. Is that the WMS and the Future Home Standard were developed together. Indeed, the second stage consultation on what we have of the Future Home Standard was released at the same time as the WMS on the 13th of December 2023. So they went forward together. This is of some additional relevance because we do have in the evidence, I won't go to it now, we have in the evidence the BPPS assessment, the principles assessment of the Future Home Standard that went off to consultation.
Can you just give a reference for that? I know I've seen it, but...
It's in the supplementary bundle,
Yeah.
And it's tab 4, page 29.
Tab 4.
Page 29.
Thank you. And I can't remember whether we have the second stage consultation document for the FHS as well.
We do. That's towards the end of the supplementary bundle. I think there was more before the High Court. There was attempts made by the parties to cut down what we...
I think a
posited.
need-to-know approach is...
Yeah, it's tab 36, page
36, that's what I thought. And that presumably describes what the second stage was about, which I had understood to be a focus on technical matters.
It's I think while there's some options that remain to be discussed, the basic decisions about the shape of the Future Home Standard, including the metric to be used, and the ambitions were set out. So one could call it technical. I think indeed that's the word that's used, but it's the basic proposal, subject to some optioneering, as sometimes said of these things, was covered in stage 1. Perhaps it's useful just to cover this off, my lord. In that tab 36, there's a table 4.1, page 225. I think we don't have everything here because there's lots of matters covered by the FHS stage 2 consultation. Some of them are relevant to other things. Some of them are relevant to domestic home energy efficiency. On 225, your lordship will see the paragraph says full details, but halfway down. That's not before this court, but there's reference to approved documents. Those approved documents, that matters because that's the document that in effect is the building regulation standard. And then table 4.1 gives you the options. So one can see it's a consultation, but on these options where they're pretty much aligned.
They look like metrics. Are these what you might call metrics?
The metrics, a consequence of this consultation was the government preferred the total emissions reductions, TER, metric.
Target emissions rate.
Yeah.
I even as I said total, I wanted
It's
TER.
page 236. That's the only reason I know what it is.
Well, you're ahead of me, but yes, target emissions rate. And one can see that.
I see the metrics are at chapter 5. Yeah.
Can you just give us the date of this document? Because I can't see the date on the document.
It was the 13th of December.
And where do we get that from?
This version is updated 4th of March 2024, and I confess I don't know exactly what those updates
So we've only got it from Mr. Palmer's witness statement. Is that right?
But the consultation, subject to the updates, and that I can confirm, probably right for me just to check that those updates aren't materials to the points I've been telling the court. If they are, I'll provide a correction. But it was the 13th of December 2023.
Thank you.
So I interrupted you. That was your point 3.
That was point 3. Fourth point, and this links to the section 19 duty. We think about the date 13th of December 2023. That was approximately 6 weeks after section 19 of the Environment Act 2021 came into effect. So for the majority of the period of the development of the policy, no duty had applied. And as the court's already observed, there are no transitional provisions giving it sort of backwards effect, as it were. This is not unimportant in the context of this case. The Secretary of State cannot be criticised in court for failure to do what he was not required to do. We know, in fact, that the Secretary of State did assess the policy against the EPPS in October. I think it's rightly called a non-statutory assessment because it was anticipatory. But I take strong issue with the notion that the duty should somehow apply to the prior development stages, even though the duty was not in force when they occurred.
I think Mr. Goodman's point, and I hope this is a fair summary of it, is slightly more subtle than that, which is that, of course, you can't be criticised for not complying with the statute before it comes into force. But if you are going to adopt a policy after the event where the policy has been formulated, then there's a duty to check in a sort of way that you might not need to if it's been embedded all throughout. Well, I hope that's a fair way of putting it.
And I'll accept the majority of that. Certainly there's a duty to think about the EPPS in the context of the stage of making policy that one's faced with. And that stage was adoption of final wording. That's 13th of December.
Well, that's not strictly legally correct, is it? Because although there'd been internal discussions, no policy had been made and no legal instrument existed to alter the statutory functions of public bodies. The thing that brought about an alteration was the publication and hence the making of the statement, and that occurred in 2013. And the making of that policy has got to comply with Section 19.
Yes, and it's what's required at the adoption stage is necessarily different from what's required at the development stage. We know that making, in the context, I think there's no actual fundamental distinction between this and the public sector equality duty. Making applies when one's developing policy as well, and if it went to that, I'll come back to it. But what's due regard to the environmental principles policy statement at a given stage is dependent on what that stage is. And my submission is that where the duty was not in effect at earlier stages that have already happened, what's not required is to go back to those very beginning stages and do effectively start with a clean slate and look at all the other options again that have already been discounted at prior stages when the duty was not in effect. That would effectively be to apply the duty retrospectively. What clearly the Secretary of State does have to do is to think about the EPPS in the context of the adoption question that was before her. And that's where there was an omission, we say not a substantial one, there was an omission. I'll come to the October assessment and February assessment in due course.
Leaving the October assessment out of account for the moment, it may partly be a question of what is due regard. If there was no duty before, and if in fact, assume for the moment there'd be no assessment, when she was finally making the policy, due regard would require her to have due regard to the EPPS. If she couldn't be sure that it had been taken into account whilst things were working through the system, then she'd have to arguably have a stricter look, not looking back like a judicial review court to see whether each stage had been done properly because the duty didn't apply then. But what's due regard may be affected by not the stage so much as the extent to which she can be satisfied that the development of the policy would have taken the duty into account.
Well, I think at the stage that it was considered by Baroness Penn, what happened in October is due regard. The problem is the lack of a nexus between the two, between that particular minister and the assessment. Because that's regard to the EPPS against the wording that was presented, indeed looking at the counterfactuals, looking at the environmental impact, doing what we say is needed and is sufficient to have due regard to the environmental principles policy statement. I think where there's perhaps, one doesn't want hyperbole either side, but where clearly it can't be right, is that after 1st November 2023, any policy development work needed to effectively go back to square one, regardless of what stage the policy was at. I mean, that would have paralysed work across government, and that can't be right. So, I mean, one might think, from that starting point, this isn't the best case to be testing Section 19. The best case to be testing Section 19 would be one where the policy development stage started after the duty was in force. And no particular criticism to the appellant, but clearly one can see from the pleadings in this case, the appellant started with pleadings about the substance of energy efficiency policy. That's in the sort of cross-judicial review, that's its campaigning tool. This is a point that's been elevated now. But I certainly wouldn't argue that this is the clearest case to test the policy, because if duty had applied in April 2023, we'd be in a different world.
It's the same question I asked Mr. Goodman, really. I'm trying to work out, you're each using phrases, and no disrespect to using phrases. If I'm the minister, God forbid, but if I'm a minister, what mental processes is she expected to go through? Is she A, only looking at the three sentences that are different? Is she B, having to say, well, the duty's never applied before, I had better make sure that the policy that I'm about to announce is one that has due regard to it? Or C, what you disagree with, that she has to go back and check earlier stages of development? What is she actually doing when she sits at her desk?
I think what we accept the minister needed was something akin to the October 2023 assessment. She's looking at the WMS and that wording as a statutory duty, so it's not the non-statutory, it's a statutory duty, and that includes, we'll accept, the changes. Had those changes been more substantial, then I wouldn't be relying on the October assessment in the same way that I am, but I'll come to those.
So it's something akin to the October assessment applied to the policy as a whole, including the changes in wording.
Correct.
Yeah. And she didn't do that.
She didn't do
was
that.
Awful.
She didn't do that. We accept that was an omission, and in part, I may say, we accept that's an omission because we do take this seriously. We accept that as a matter of policy making, that should have been before the minister, and it wasn't. I don't make any particular apology for it, but we do say part of the reason was there was a change in personnel, part of the reason was the duty was new. In any event, we do accept that. What we don't accept is that there's any substantial breach or unlawfulness in this case, so I'll come to that.
Because if there is a breach, the starting point is, normally, that there's a remedy. Quashing, usually, sometimes at least a declaration. And what you've got to persuade us of is that the significance of the breach, either because of the extent of things that had in fact been done or there was no need to do it, or because it's been looked at again, not to rectify, but to make sure that going forward the errors have been corrected. You need to show us both of those, really, then, don't you?
Yeah, I do, and I think that's in fairness to the parties, that's been the focus of the arguments below and so far in this court too, so that's right. So fifth factual point, as far as the changes in November and December are concerned, those came out of the sort of finalisation process of the wording of the Written Ministerial Statement. As I said, we accept they were not assessed against the EPPS, but those changes are distinctly minor, and just want to briefly remind you of them. This requires a comparison of the document, the October document, supplementary bundle, page 175, and the WMS itself.
The October documents and the supplemental bundle.
Supplementary bundle 175, yes.
And the WMS?
Is the back of the 304 bundle?
304 to 305,
Oh,
24 bundle.
Yeah.
And there appear to be three differences of any kind, so three textual differences. The first one can be seen on page 304, and that's the sentence that was inserted into the main substantive paragraph at the bottom that starts with the proliferation of multiple local standards. That's a textual change. That, though, is just an articulation of the justification for the written ministerial statement, i.e. the policy issue that the written ministerial statement was trying to resolve. Mr. Goodman was asked in the course of discussions yesterday if the point had been raised anywhere else. He suspected it had been. He's right. I just give a reference to the court. One can see that, for example, in the 26th of April 2023 submission, supplementary bundle page 152, and Annex B to that submission, page 161. Annex B is effectively a list of different local authority standards. That's the first point. The second point, we can call it the flexibility point. To understand this, it's necessary to compare the sentence on page 175 that starts, the paragraph on 175 that starts to be sound, with the two paragraphs at the top of page 305, core bundle 305, being effectively a bit of redrafting. So starting with 175, one can see to be sound, it says local plan policy should make clear energy efficiency standard need not be met where applicants can evidence that it's not technically feasible to do so, saying effectively that local policies should give applicants on planning permissions for development this option, technical feasibility. And then one can see on page 305, top of the page, how that's set out there. The to be sound point is on the second paragraph, and there's been a reformulation at the top where plan policies go beyond current or planned building regulations. These policies should be applied flexibly. So I think the change there in my submission is slight. Both relate to the application stage. Both say that policies should make provision at the application stage for applicants to rely upon technical infeasibility in certain circumstances, and it's set out relatively strictly, actually, grid connections, etc. The only difference is that in the final version is this suggestion about applying flexibly. So in a way it makes express or adds some force in a way to what might happen on a development control decision. But in my submission, that's already there in the draft version, which tells us without using the words about flexibility of application, that policies that don't do that won't be sound. And as my Lord may well recall, if the policy is not sound, one gives less weight to it, hence applies it flexibly. So it's really just spelling out the same thing in a slightly more express language.
I thought sound had a legal significance, that an inspector had to decide if a plan was sound, but that's a mistake, is it?
No, my Lord's right. It's in the 2024 Act. It's just that soundness is not defined in the Act, and you have to go to the National Planning Policy Framework. I think Lord Justice Calmer, as he was, said something about this in a case, or maybe Lord Justice Laws. But
The soundness is in the statute.
indeed, soundness is such a serious point that if it becomes a fetter on the power to adopt the plan unless you go through the main modification procedure.
That's in the plan, that's in the 2004 Planning Purchase Act.
Because the way I read this is that whoever did the first draft was just thinking about that process. Oh gosh, they're not going to get through the inspector unless they allow for flexibility, and he was just looking at whether that plan would be enough. Whereas when you get to 2023, somebody's realised there's more to life than meets the eye, and it's not just making sure that your plans are sound. You might already have got plans, but even when you've got those plans, you've got to apply them flexibly. So it's moving beyond a process of assessing soundness to a process of making sure that there's flexibility at the individual decision stage, is how I read it, but I'm not a planner. So.
That's I think that's fair.
Right.
I think the point I'm making is that it's a logical development, so one moves beyond, but it's almost inexorably follows. If you've got policy, that national policy is what it is, it's a material consideration in planning terms. If you've got policy that talks about soundness, local plan policies not being sound if they don't do something, then on any planning application, your inspectors or applicants or local planning authorities could point to that and say, look, there's your material consideration, apply it more flexibly. So it's not a major difference, it's distinctly minor.
Well, the policies are being formulated for the purposes of being applied to planning applications in any event. In fact, what's going on here, looking at it again, is that the draft in October was saying to be sound, to get through the test leading to adoption, the flexibility concept should actually be in the policy itself. Yeah. Whereas it's not so stringent procedurally when you come to page 305, because even if you've got a policy which hasn't said this should be applied flexibly, nonetheless you apply it flexibly when you come to planning applications by reference to technical feasibility. Have I understood correctly?
I think that's fair. It's a different emphasis. It's probably stronger in one sense and weaker in another. More prescriptive in one sense and less prescriptive in another. But it's of the same nature. That's perhaps the key point.
It's about technical feasibility when you come to apply the policy, whether that concept is expressed in the policy or not.
The third point, and this is the third textual change, is the penultimate paragraph on page 305, which wasn't in the October version at all. Your Lordship saw that, called this the intervention point, perhaps. So my submission on that is simply that that's says nothing other than...
What are the relevant criteria for intervention? I mean, one's aware of criteria for calling in planning applications. Are there similar criteria for...
I suspect there might well be. I think I recall a letter, but that might be a call-in.
I mean, because in terms of planning applications, the power is exercised very rarely.
Yeah. It's there. It's not referring to particular criteria, but just referring to the fact that those powers exist.
No, it's we're on page 305.
Oh, I'm sorry.
Yes, at the end it says in line with relevant criteria for such intervention powers.
I was reading before that. I don't know if there's a letter similar to the one I've seen about calling. We can check if we have a chance over lunch and update the call. But I think it might well be. It would
be useful to know.
So overall, finishing on this fifth point, these changes were distinctly minor in my submission, did not materially change the written ministerial statement, and therefore do not materially change or reduce the relevance of the October 2023 assessment on which I rely. Sixth point is a small one. The minister who made the decision on the 13th of December, of course, was Baroness Penn, but your Lordships will have seen in Mr. Palmer's witness statement, Paris 45 and following, it's a supplementary bundle, page 61. what in fact happened. So while the assessment that was put down as February, in fact, there was some ping-ponging with the Secretary of State, who was delegating things down to his ministers. And for the reasons explained there, in the end, the minister who agreed to take the final decision on the WMS, this is the March decision, was Minister Rowley. Slightly different capacity, but same department. That's para 48. I said it partly because there was also reference to she in terms of the February assessment. Strictly, that should be he. Small point, not of no relevance, given that.
Well, it's not necessarily a small point, given the reliance it's placed on the National Association of Health Stores principle. And Mr. Rowley won't have forgotten what he did in October.
That was my subject 2 point. Perhaps I'm understating it. But
I say it's not a small point. It's not necessarily a small point.
Certainly, in terms of a point that was made by my learned friend that I can perhaps deal with now, in terms of 1 day, the criticism taken that this was dealt with in 1 day. I mean, let's see why it couldn't be considered in 1 day. But here, the actual minister who did take the decision between the 18th and 19th of March 2024, as one can see from para 49 of Mr. Palmer's statement, was the minister who looked at it all back in October. So the final point, sort of 2 parts to it, related parts, is to come back to the substance of the written ministerial statement itself. So that's again at page 304. And clearly it needs to be looked at as a whole to understand what it's saying, and the claimant's point at the end, but the beginning is important too. The second paragraph on page 304 refers to the long-standing debate. And it's not a new debate, it's actually reference to it in lots of the documents before the court, goes back years, between a single set of streamlined national standards and varying, but potentially more ambitious, some more ambitious, some less ambitious local standards. And it's a matter of debate as to which is more effective. Do you have a streamlined national approach, which national house bills, etc., can get on board with, or do you have multiplicity of approaches set locally? In terms of the views of the Secretary of State's second element of it, the view is taken that a national streamlined standard, this is the FHS, is compatible with net zero targets. That is preferred. And in that respect, and really the only environmental element of this policy is climate change. But in that respect, the written ministerial statement is environmental policy. It's justified by environmental aims, and clearly the debate is about energy efficiency and reducing climate change emissions. It's informed, as I've already said, by substantial consultation. We've had over many years, I think it goes back to 2019, consultation on this topic. And some of the information that was relied upon in the EPPS assessment, the marginal abatement cost curve analysis that is picked up by Mr. Palmer in his witness statement as well, that's drawn from this extensive consideration that's given to the policy over time. So I mention that in part because one has to have regard to the wider context, but in part because we're not here looking at non-environmental policy. We're not here looking at Department for Work and Pensions policy that has environmental impacts, but they've not been considered at all. We're not looking at a Department for Transport scheme that just hasn't looked at environmental impacts. And it matters when one looks at the references that are replete about the point of the duty. It applies to all ministers across government. Here we're looking at policy that almost necessarily, by definition, is about climate change, and it's based upon those factors.
In light of the discussion we had with Mr. Goodman yesterday about what Section 1 means, and the argument that Section 1(c) permits the local authority to choose more stringent but nationally authorised standards. I'm beginning to wonder what this policy does at all, because it says any planning policies that propose local energy efficiency standards that go beyond current or planned buildings regulations should be rejected at examination. But they were all there'd be national standards anyway, wouldn't they? So what do they mean by local energy efficiency standards? Did you follow me, sir?
Yeah, I think so. I'll do my best to answer, and then perhaps my lawyer can tell me if the response doesn't make sense. The local energy efficiency standards would be one set at the local plan level by the local planning authority that are bespoke. Anything national is either in the form of current building regs, that's requirements, or as set out here, because it brings it in, proposed building regs. So in terms of section 1(c), my reading of it is that this presents what's proposed as something that local authorities can draw on.
Yes, this makes it a national guidance or national policy, so it can be the draft FHS rather than having to wait for the full FHS.
So it's consistent with 1(c) in that it gives you what's proposed coming down the tracks as an option for now,
exactly,
and allows you to exceed what's the current building requirements up to that.
By reference to the proposed ones, the FHS ones. That I understand, but it's what it means when it says any planning policies that propose local energy efficiency standards that go beyond current or planned building regulations, because they could only be other nationally approved plans on your case about section 1(c).
Yes, well, it goes beyond section 1(c) in that sense.
Right.
It's so it's consistent with what's set out in 1(c) up to the FHS standard, but it goes beyond 1(c) insofar as it's providing guidance. And this is national policy guidance, material consideration, etc., etc. It's providing guidance to local planning authorities that may go even further.
So, do local authorities have powers separate from section 1 to adopt local plans or development plans, whatever they're called, which impose standards that are above the current regulations and aren't authorised by national guidance or policies?
This is a question that arose in debate yesterday as to whether the specific provision in section 1 of the 2008 Act sort of acts to override or exclude any inherent power or power under the planning acts that local planning authorities would have to make policy in any event. I think the answer to that is that the Planning and Energy Act was not intended to exhaust the possibility, but it was intended to provide a framework for the possibility in circumstances where generally one might expect a national framework to be followed. But there's a tension there. It's one of, not the only, tension within the Planning and Energy Act and the wording as to how it's supposed to function. Difficult to offer a definitive answer, except that I don't think that it's intended to exhaust the ability of planning authorities to set energy efficiency standards. I think fairer to say it's declaratory of something they could already do, and within limits.
Well, that can't be right.
There's not much point then in having the fetter in section 1 of the 2008 Act. You can just circumvent it by relying upon a general power to make local policy.
Well, it's probably now respond a bit tensely.
I mean, it also makes no sense of the deliberate choice by Parliament to amend the bill, as you pointed out, to introduce subsection 2. Because there was no fetter in the original bill.
There was no, well, we can call it a fetter, or we can call it a...
It's a constraint.
It's a constraint on the exercise of that.
Constraint
power.
is a better word. It's a restriction.
It's a restraint on the exercise of that power. It is.
Yeah. But then it would become OTOs if you could just ignore all that and say, well, I rely upon my general power to make local policy. Because, as I think was being said yesterday, before the 2008 came along, the general power was there in any event, but it wasn't constrained by any restriction, as we now find. So,
because I then wonder what this case is all about, because if that's what this policy does, insofar as it's relevant to Section 1, it's helpful. It provides an additional national guidance and puts beyond doubt that they can adopt the FHS in draft and don't have to wait for it to be adopted. And the only problem is not that it conflicts with Section 1, but on what you're saying at the moment, the sentence that I read out may or may not be an improper restriction on some other power, which we haven't yet been shown or taken to. Did you follow my concern?
I do, and I think it comes down to a question which hasn't been asked in this litigation, but potentially arises as to whether the effect of Section 1 is, as I can well understand, to be construed as, to exclude the power, so it can only be exercised. Energy efficiency policy making powers can only be exercised in the terms of Section 1(1)(c) of the 2008 Act. And if that's right, then there is a question as to whether the WMS goes further, or how it's supposed to be compatible or fit with it. That's the statutory power, but that's not the challenge I'm faced with here.
Well, there is an oddity about Section 1 of the 2008 Act, following on from my Lord's question. Let's imagine that the 2023 WMS hadn't been conceived at all, or even the previous one. A local authority wanting to exercise the Section 1 power would have to point to some regulation, national regulation or national policy, which identified a standard greater than the building regs. And if the Secretary of State had not made any such policy, you wouldn't be able to rely upon Section 1. To get round that difficulty in part, it's suggested that standard means metric. But if you interpret the provision in that way, there's still got to be a metric in a national measure.
I'll come to the argument about standard meaning metric, and I'll come to all of these points on ground 2.
So it's only because you've got the WMS, following on from my Lord's question, that it's even possible for a local authority to exercise the Section 1 power. Because is there any other national standard, if we ignore the WMS, which sets a national energy efficiency standard greater than the building regs?
At present, my understanding is the WMS is doing that work.
No, but I said if you exclude the WMS.
No.
No.
But I can check that.
No one's pointed to one anyway.
Helpful perhaps to remember that when the 2008 Act was enacted, and it is intensely dependent on its surrounding context, it depends for its operation upon the policy and regulatory context. The Code for Sustainable Homes was an approved set of standards that was there. Clearly that's...
But that was something presumably then, until that code became defunct, you could draw on to actually apply the power in Section 1. But whichever way you cut it, you need some national standard which engages the power as drafted.
You do. The exercise of Section 1(1)(c), that has always been our submission. It's clearly constrained in the drafted terms. At the moment, that's the WMS that provides that ability for it to operate. It might be debates like this, just to foreshadow it, that were one of the reasons why in the High Court the judge admitted that the Hansard materials tried to understand what the thought process here was. I don't think I can insist anymore now, but I will come back to this on ground 2.
And when you come back to it, perhaps you won't lose sight of the problem that I raised at the beginning. What I was trying to work out is what the policy meant. And when it says any planning policies that propose local energy efficient standards, they've got to be rejected if they're not robust and so on. My first thought was, well, that can't be, well, what does that mean? Because where are these local energy efficient standards coming from if they're not from Section 1? And what is that what kind of local entity standards are they applying to if it's meant to be something different from Section 1. And I do think it's reasonable for the Secretary of State to be able to tell us what she was trying to restrict or govern, whether she was trying to restrict things in Section 1 or whether she had in mind other planning policies that she was trying to restrict. If you follow me.
I think so, and if you'll...
But you can come back to that if you like when you're doing Section 2 or Round 2.
So if I can press on with Round 1, in overview, as I've already explained, it's clear we accept that the Minister who adopted the final version of WMS did not have regard to the EPPS. But that doesn't mean that due regard was not had to the EPPS when making policy. It means that due regard was not given to the WMS at one stage in making policy, and in the circumstances that error is technical or minor, for the reasons that I took out in my skirts and argument. Take one issue with what Mr. Trayman said to the OEP yesterday in this context, where he said that the OEP does not accept that there's such a thing as a case of limited breach. Now, if what he meant by that was to mean that there are only one category of serious cases where there must be quashing and other cases where there must not be, I don't think that's what he meant. We don't accept that. And this is a case of a limited breach. It's a case where, in my submission, in substance, there was due regard. It's a technical.
There wasn't a due regard with due respect. She made the policy on the 13th of December. She didn't have a clue that Section 19 existed. There was therefore a breach. The next question is, should there be a remedy? And it may be relevant in assessing the remedy what the significance of the breach is. But if Parliament tells the Minister you must have regard to something, and she doesn't, through fault or inadvertence on her part, or the parts of civil servants, I don't see how you can say that due regard was had. She never had regard. She made the policy when she promulgated it.
But the basis on which I can say my due regard was had is that one can look at the earlier assessment, where there was a due regard in the earlier process, the development process, albeit before the judicial came into effect. And it is possible, we'll come to this because it's an issue before the court, it is possible to discharge a Section 19 duty post-effect. The due regard can be had at that stage too.
I find this a very difficult argument because you've previously been arguing against retrospectivity. Now when we come to this part of the debate, you're saying I can pray and aid something which happened when I wasn't under a duty to show that I satisfied the duty when it did apply as a matter of law. It's a very difficult analysis, and an easier way to approach it is to say, well, there was a breach, there was no regard, due or otherwise, to the NPPS at a particular point in time, but it's then a matter for the court to assess the significance of it when you look at the overall chronology.
I can see that, and it may be more semantics than anything else, but in my submission it is right that due regard can be had to Section 19 duty, so that Section 19 duty is capable of being discharged after the adoption of a policy. That doesn't, I'm not arguing that somehow cures or it obliterates the earlier failure, but it's relevant to the question of overall compliance.
No, it's relevant to remedy. There's been a breach. She acted unlawfully. She should not have issued the statement in 2023 without having due regard to the statements. That's the short answer. Parliament has said to the Minister, you must do this, and she didn't. The next question is what is the significance of that failure? And it may be, if you've actually done in substance similar things earlier and there's not been any change between October and December, that may minimise the significance of the illegality that the Minister has committed. It may be that going forward in March, somebody looks at it again and says, no, it's okay, actually, it's all right. So you know that from March onwards, the continued application of that policy meets the requirements of the law. But between the making of the statement on the 13th of December and the revisiting, there was a state of unlawfulness.
The subject to October and the...
No, not subject to October. There was still a state of unlawfulness. The Minister who chose to make it didn't have regard to it. she might have decided she disagreed with Minister Rowley. We just don't know.
I think these points unfold in the same way. And critically, I'm not saying there's not been a breach. I just say it was a very minor breach. So we are looking at then consequences, and there's a number of ways of doing that. I'll come to that. But there's 3 potential bases for it, as appear from the authorities. There's the line of authority in A1, it's an AG, substantial compliance overall. There's the question of the court's inherent discretion about relief under section 31(2)A. So I'll come to those, but we do get to that. What I say is that the surrounding circumstances are relevant to all of that analysis, and I do say and maintain that despite there may be a breach at a point in time, it is possible to discharge the section 19(1) duty retrospectively or post facto. Now, that doesn't mean you're curing it. It simply means that one's taking stock, doing another exercise. It only applies from that date it's done, but it is a proper and lawful discharge of the section 19 duty where it's properly done. And I emphasise that because that might be the issue between the parties as I understand it. Is that well, you can't do it. It's forbidden, and the OEP takes a strong line on that. The appellant doesn't take such a strong line, but the question is whether it's possible as a matter of principle. I say it is, not saying that nullifies or obliterates any previous breach. So it's relevant, though, to the position before the court on a challenge. I had one other small preliminary point before I get on with submissions. The OEP relies upon various extracts from parliamentary material to support its points. There's one, I think, actual Hansard record before the court on the 2021 Environment Act. Clearly that's not admissible. Mr. Tromans also went to one extract, I think, via a House of Commons library publication, which is effectively a record of government's response to the EFRA, Environment, Food and Rural Affairs Committee. That's effectively part of the parliamentary background to the bill. That sort of document is not, in my submission, a helpful aid to construction of an act. And perhaps the reference that Lieven went to, where there's something about giving greater weight, is a good example of why it's not. These are documents drafted by civil servants. Really, if one wants to understand what due regard means,
Read the act.
So, structure of what remains, I'll set out a few comments on the nature of the duty. I cover that in my skeleton in some more detail at paras 34 to 52. I'm not going to cover all of that ground. I'll pick up on the points that are more live in the discussion before this court. Then I'll explain the circumstances and extent of the breach in this case. So effectively that's looking at those surrounding circumstances. I can use that abbreviated term. And then finally set out why the judge was right not to grant relief. Given those 3 bases outlined a moment ago. So the first part is about the section 19 duty itself. No dispute that the purpose of the provision is to contribute to the improvement of environmental protection by ensuring due regard is had to the policy statement on environmental principles in making policy. That's clear from the statute itself. Maybe worth having it to hand, but you've seen it a few times already, but in the Authorities Fund, tab 6, page 89. Emphasise applies to all ministers, a minister of the Crown, and to all policy. Its potential application is very broad, and as one can see from various references that we've seen in the EPPS itself, it's applied across government. The keywords are due regard, except that was strengthened in the process. Originally have regard. But due regard, fundamentally, little more can be said about that than it's the regard that's appropriate in all the circumstances. Reference for that, the CAO case in the Supreme Court, 2024, para 75, authorities bundle pages 800.
Sorry,
Para 75.
thank you.
It does not mean, insofar as that's suggested, some higher or greater status or regard or weight, and that is inapt. What it means is that the statement, policy statement on environmental principles, should be considered conscientiously and proactively, not that the principles have some elevated status.
Well, status and weight are different concepts, aren't they? I mean, it does have a different status compared, and was meant to, compared to material considerations in general.
Yes. Weight.
It was an enhanced duty or obligation, so it has that status, but that the status doesn't have any implications for weight in individual cases.
In essence, what it is to require, and I suppose this is the status point, it requires you to
Yes.
move those, the principles as expressed in the policy statement into your decision-making process. You have to do that. But it doesn't affect weight. And one can pause there. I mean, had that been intended, there's obvious ways in which that could have been done. Special regard is a well-known phrase from the listed buildings context.
Yeah, but even then, that doesn't change the weight, according to Court of Appeal Authority, Brams Hill. It doesn't change the weight that in a particular case you give to a conservation aspect. It means you've got to apply care.
And of course, as Mr. Tromans drew the court's attention to, the idea of according to also wasn't followed. But the duty is just and no more what it says, which is due regard, i.e. appropriate in all the circumstances. Staying with section 19.1, the subject matter of the duty is significant. It's due regard to the policy statement on environmental principles, currently in force. We've got the version of that in the supplementary bundle. And we know, if we turn back to section 17.2, page 86, the policy statement on environmental principles is defined at subsection 2 of that provision, section 17. Statement explaining how environmental principles should be interpreted and proportionately applied. So it's to have due regard to a statement that actually talks about and tells us how policy should be proportionately applied.
Sorry, could you say it again? How
the environmental principles, how the environmental principles should be proportionately applied. So it's critical in understanding at any one time what the duty actually requires to look at the EPPS itself. And I just want to make a few comments on that. Staying with the statute, as Mr. Tromans emphasised, it's a formal document, it's laid before Parliament. We see that in section 18, the following page. And if we turn to the EPPS, that's the beginning of the supplementary bundle. I'm not going to go over points where references have been made to this. We accept it supports the idea that early in that policy-making framework you embed the principles and you consider them, all of that. That's clearly part and parcel of the duty. I do want to draw attention to 3 points. Firstly, each one on page 10 is the focus of the emphasis on environmental effects. There's a meaning of environmental effect there, and then the paragraph under applying the principles fourth line down, potential environmental effects of policy option. But understandably, one's looking at environmental effects. Second point that flows from that is on the next page, page 11, and this is under the heading proportionality. It's the middle paragraph, the one that starts, environmental effects will be different for each policy. I'll just ask the court to remind itself of that paragraph. This is what I call in my skeleton arguments the procedural aspect, the procedural side of proportionality. And it's there in black and white in the EPPS itself. And it's very clear, sort of in the middle of that paragraph, in cases where potential effect is limited, this allows policymakers to apply the policy statement in a lighter touch way. So what's required then differs depending on that analysis of effects. And it goes on, the avoidance of doubt, to say policymakers are not required to replicate the environmental impact assessment process. So it's not a formal process, there's no particular form in which this must take place. People may think that it's about the culture of decision making rather than some kind of tick box exercise. And the third point is over the page on interaction between the principles. So under that heading, it talks about the integration principle, looking for opportunities to embed environmental protection into policy. So the integration principle is overarching, so that's going to apply generally, I think is what's suggested there. But then the next paragraph that starts not all environmental principles, that makes clear that it won't be the case that all of the environmental principles are always going to apply.
Well, only two are relied upon in this case.
And right, so
Yeah.
the others aren't relevant. But insofar as it's said, you've got to look at all the principles, but that's not the case. One has to do a staged approach.
You look at
one
the relevant
finds that in the apologize.
No, sorry, you just look at the relevant ones.
So I draw attention to these points mainly because the practical reality is that what's due, i.e. what is due regard, is dictated by a judgment or assessment of environmental effects. That's recognised in the EPBS itself. So the last point I wanted to address in principle, and this was the one about which the OEP expressed most concern as I understood it, is a point about timing. That's when the duty is discharged. That's addressed in my skeleton argument for your notes of paragraph 39 and then 48 to 52. I'll make some headline points here orally as well. We know from the statute the duty must be discharged when making policy, and if your lordship still have the statute in front of you, it's section 47(1). And there's a definition on page 95. We're told about 3 points down, I think Melanson went to this, making policy includes developing, adopting or revising policy, and then for completeness, policy, but halfway down, includes proposals for legislation. So one doesn't have exhaustive definitions there. It was said on the other side that these are 3 entirely distinct stages, i.e. developing, adopting and revising. Wouldn't accept that entirely. There are obviously 3 stages, but not distinct, and it's possible for them to overlap with each other, possible for them to even be ordered in a different way. Nor, plainly, is the list exclusive or exhaustive, because it says making includes developing, and within the environmental principles policy statement itself, I think just take a note of this. I mentioned my skeleton argument, but it suggested that the duty may apply when repealing policy as well. So consideration of the revision or repeal of policy will, potentially will, I should say, engage the duty. And therefore, must logically follow that potentially the duty would be engaged by a decision or a process of thinking about whether to reopen a policy position in order to revise it. It does have a continuing nature in that sense. It doesn't stop. It's capable, would apply at those later post-adoption stages as well. And that's why, and perhaps it's a short point really, that's why I say that it's not call it retrospective, it's probably not helpful language. Post facto or post-adoption, maybe the easiest and most neutral way of putting it, post-adoption consideration or processes are capable of discharging the duty.
At that stage?
Absolutely.
For the future.
At that stage for the future.
They don't discharge the duty if there's been a breach in the past. It goes to relief.
It does, but it's important because it appears to be an issue between us as to whether it's capable of doing this at all. That's not a point so much taken by the appellant, but by the OEP.
Well, I think the OEP have accepted this, and Mr. Tromans did yesterday in express terms. It's paragraph 49 of his skeleton.
Yes, exactly so, my lord.
Well, there's a practical point. If one in Mr. Tromans' skeleton, and I'm happy to abridge things if I can. But
I mean, he may say that the relief will be exercised more strictly than you would accept, but that's a question of degree, not principle.
Yeah, I don't. I mean, once one accepts that it's possible to discharge the duty later, one's perhaps that this does move us on, and one of the reasons I pick up this point is a couple of references in the OEP skeleton argument, paragraph 43 actually, not 4, I think it was 48, which you referred to. It's paragraph 43, page 74. If an assessment is carried out retrospectively, it will not be possible to have meaningful regard to.
Paragraph
43. That's one articulation of it. So there, and it may be a short issue, it may not even be an issue, but we don't accept that. In my submission, it is possible to do a post-adoption assessment in good faith.
If something has gone wrong and you haven't done it, clearly it's better that you do it now. And you would hope that they would do it properly now. And you'd hope that if it is done properly now, you don't need to give any relief that would affect decisions taken after now. We're in a different ballgame. Should there have been any remedy, did the judge err as a matter of discretion by saying, well, I'm actually not going to grant a remedy in relation to that period of time when there had been illegality?
Well, I think the judge clearly didn't think there was any point in granting a declaration and didn't do so. So that's where the judge ended up, having regard to, in particular, the February-March assessment. As I say, I don't want to get stuck on semantics, but it's in both practical and legal terms, it is possible to discharge the duty post-adoption from that stage.
Well, that's, I think, the bright line where Mr. Tremors says you've crossed the line there, because you can't discharge the duty as a matter of history. The minister didn't have regard to it, therefore there's a breach. And then the question comes, what, if anything, do we have to do with it in the light of what happened in October and what happened in February, about which Mr. Goodman's made detailed submissions?
I think there's probably common ground on this.
Yeah.
I see my letter from Mr. Tremors is about to rise, but I'll let him do so.
Simply to say, my lords, if it assists, I think the point is made clear at paragraph 46
Yeah.
skeleton.
Well, it is, thank you, which we've got. I don't think there's anything between you. There is, in this case, an admitted breach. It hasn't been put right by February because the breach occurred, but what has happened in February may be relevant to other issues.
The last point on this is just to briefly mention PSED case law on this. I can probably do this mostly by reference, because again, maybe there's not a huge amount between us. What's the point of semantics more than anything else? Rowley is the first case, and Mr. Holmes went to this. The judge relies upon paragraph 44 of the judgment. Probably worthwhile, first of all, as the criticism was leveled at the judge, looking at what she said about Rowley.
Which is where in the paragraph?
Paragraph 4 says it's core bundle 139, tab 9, page 139.
Paragraph 44, thank you.
So it's about halfway down. It's apparent from cases such as Rowley that a later assessment can meet the statutory duty. That, in my submission, is correct. All one needs to do is understand that the judge is saying from the point that it's done. And then goes on to say where that's done, the question is one of substance, etc. Looking as is appropriate for a court in judicial review at that subsequent assessment. I don't think there's anything inconsistent between that and Rowley.
It is Rowley in the authority as well.
It is. So Rowley is tab 23.
Thank you.
And it's perhaps a particularly complicated case, both as one can see in terms of how it's pleaded and the number of sort of points and how they then fell to be analysed by the judge. I didn't see that it was pleaded, that the past breach was pleaded. There was a focus upon present or continuing breach in the analysis. But the point that the judge is making, paragraph 43, is that a public sector equality duty assessment that comes at a later stage, he says, at the doors of court, can satisfy section 149. It's as simple as that.
If you look at paragraph 10, it's not an easy judgment to understand. He seems to be saying there's a then and a now, an historic and a prospective thing. And when you read it, he says they didn't do something on a particular set of dates, i.e. there were two briefings in September and October 2020 when there wasn't British Sign Language interpretation. But now, he says, we're looking at the continuing future briefings, and there weren't any sign language interpreters then. And the PSED seems to be relevant, it seems partly to the first situation, did they break it when they did the first two? But they've also got to decide whether there's been a breach by failing to have BSL sign language people at the briefings going forward. So it may be that that's what he's dealing with.
I think if your logic turns on to paragraph 17, certainly as the issues were crunched by Mr. Justice Fordham, the then claim, is question 1, that doesn't seem to have PSED as part of it for whatever reason. It's the now claim that does. Yeah. So that issue didn't arise. But the PSED that was produced was a post adoption, effectively the same type of PSED. It's only applying to what happens now in that case. But in my submission, what the judge says at paragraph 43 is consistent with the basic submission I'm making, which is that post-adoption assessments are capable of discharging, I say section 19, but clearly also section 149, the public sector equality duty.
Well, in terms of current breach, because if you look at line 2 of paragraph 43, that's what the judge is concentrating on. Yeah. And that's what the issue was. He doesn't go back and say there wasn't a breach at the time.
And that point, that point is pretty clear in a lot of authorities, i.e. doesn't go back and correct what happened in the past, but you can expressly discharge a Section 149 duty post-decision, as it were,
Later.
in a number of authorities later. I could just give the court references, perhaps, to other authorities. So I think the point's probably not significantly in dispute, but I think it is an important point of emphasis. Hurley and Moore, that's tab 11.
I just wonder, before we get into the details, whether this is all just misunderstanding or use of words. The fact that you didn't act lawfully in December 2023 doesn't mean that you are prevented from acting lawfully in March 2024. But when you're doing the exercise in March 2024, you are doing it for the purpose of seeing whether going forward you're acting lawfully. You are not seeking to say, because I've done it now, and because I'm satisfied now that it's okay, you can treat the events of the last 3 months as being lawful, because they weren't lawful. So the failure doesn't prevent a subsequent attempt to do your duty, but the subsequent doing of the duty doesn't excuse the initial failure either. Is that a fair way of putting it?
Yes.
That's also consistent with the situation which could arise where a policy is actually quashed for breach of either this duty or the PSED, and the minister, no one seems to seriously suggest that the minister could not decide to make that policy again. So one is left asking, well, what's the big difference between that scenario as opposed to the one we're dealing with here, where before any court consideration, the matter is looked at afresh. But if you do look at the matter afresh, presumably you do have to take into account possibly any earlier failings, if they affect the way you're doing the exercise now. The trouble with this discussion is that we're talking in generalities, but policies are of greatly different varieties. Some are rather complex. This is a relatively straightforward policy.
It's straightforward.
I mean, local plans are quite complex policies, so Parliament's intervened now, so when the court quashes, it can quash from a particular point in time, so as to cure or address, is a better way of putting it, the moment when a legal defect occurred, and therefore can put right the way in which that affected the plan-making process. You see that also with strategic environmental assessment for plans and programmes, because it is a process. But to light upon a sentence in authority which suggests that you can comply with the duty at a particular subsequent point in time isn't necessarily telling you very much about what should be done in some other case.
Not necessarily, but it can be very fundamental, and one sees that in it. I'll come to these points on relief. I think it's probably easier. In terms of principle, I rest my case there. One other point on principle only, it's under this particular heading, is in response to the OP argument about the court setting out principles on Section 19. We, so far as the court may be tempted to take up that invitation.
Is that paragraph 51?
It's paragraph 40, they say it's important to require principles, and then I think it's 50 or 51, they set out a sort of list of principles. Many of those are, I should say, not really objectionable, but then they're not really an issue in this case.
Yeah.
Some of them are perhaps, we might say, a bit too strongly stated, but it's not really the role of the court to do that in litigation. There's a couple of other points on that too, on the general invitation. Guidance of that nature is necessarily of limited practical utility, given the diverse, heterogeneous way in which the duty applies, because it applies so context dependent. But in any event, we've already got, away from court proceedings, guidance on the duty. First, we've got the PPS itself, which tells us how it should be applied. So there's a distinction between this and the PSED. And second, as one might expect, and the difference between this and the PACD is that this is a duty that applies to government primarily, so it applies to arm's length bodies on occasion, but primarily it's applying to ministers. And there is guidance that's been developed for use across government. And in that context, the OEP has a role. So it's relevant that the court's at least aware. And this is right at the end, I think, of the authorities bundle.
The first authorities bundle.
So of the first authorities bundle, yeah, I've split it up actually because there's a lot there for me.
Yeah.
It's tab 39 and 40, page 968.
So divided 39.
Yes.
So this is lots of interesting stuff in this. This is the OEP's review from February this year of the implementation of Section 19 duty. I'm not going to ask the court to read it in any detail, but one can see from the executive summary, which is page 977 and following, discussion of it, and then there's some recommendations. The middle paragraph on 978, you'll obviously see reference to good preparation and development of processes to support the implementation of the duty. There's then a government response to that I think was actually published at the same time as replacement skeleton arguments, in this case, for what's worth. That's at tab 40, page 1018. And two brief points on that, so one can just see where we're at. Top of page 1025, response to one of the recommendations. With reference there to EPPS toolkit of resources, continued development of that. So in terms of guidance, that's in hand. And then in the context of the particular point that was made by my learned friend, I think he urged on the court to say something about record keeping, and the question was raised by the court, is that really necessary? One can see on page 1028, 3 paragraphs up, what's said there. Department should probably maintain internal records. So neither appropriate or necessary for the court to give guidance outside the ambit of this particular dispute. So that brings me on then to the circumstances of the breach in this case, and this is, as I recalled it earlier, so the surrounding circumstances. Two most important limbs to that are the October consideration and then the February or March consideration. I cover the October assessment, if I can start with that, in my skeleton argument, paras 59 to 60, and one can see that assessment in supplementary bundle page 21.
Did you say?
21 supplementary bundle.
Yep.
That's what the assessment is. It's applying to the October version statement that we've got at 175. Don't ask the court to turn to that. We looked at that earlier. Insofar as this statement is concerned, I just draw the court's attention to a number of features of it, though they speak for themselves. It identifies the impacts from the written ministerial statement and the benefits of the future home standard. In my submission, given the covered, the close connection between the two policy mechanisms, it was obviously right to consider them together. In fact, if not considered them together, would have been somewhat perverse. But it does separately consider the impact of the WMS as well. And one can see halfway through the second paragraph, where it starts with our assessment, any energy efficiency improvements would return marginal carbon saving benefits compared to the cost of doing so, ... diminishing returns. So it's engaging with those impacts, opportunity costs if you like, and finding that they're not significant. That's the bottom, on balance. It's also in the penultimate paragraph setting out countervailing considerations in terms of housing availability and also the transition to cleaner energy stock. And noting that there are concerns that if you allow a multiplicity of local standards, that could have an impact on that transition.
Can I just ask one question? The penultimate paragraph, the last sentence, thus prolonging the use of less energy efficient older stock. I mean, there's no suggestion that people are knocking down viable houses at the moment, is there, when you build new houses? So is this really fair to put in there?
It's a bit of an afterthought point. I think that the substance of it's in the previous sentence. Insofar as people will move into new houses and that will give opportunities for older stock to be restored, maybe something in it. But I think I'd accept it's a small point.
Anyway, I mean, we're not dealing with the quashing of this guidance. It's just the points you're making on it.
Well, I mean, I don't think that sentence is. It has no possible basis. I'd say it's a small point only. I think the key point there is the counterfactual of varying standards that have viability impacts or reduce or delay the supply of new homes. And then there's a link between new homes and old homes, in that one has an active market out there.
Well, I'd read the two sentences, the previous sentence and the prolonging sentence together, and I thought it was simply making the point that if there are lots of varying local standards, businesses might be less willing to build new homes because there are different standards, and if they're less willing to build new homes, that means the older ones, which are less energy efficient, will remain in use longer. That's what I thought it was saying.
Yeah, and I think
as my Lord says, so what, they're not going to knock them down, they're always going to be there.
Well, there will actually be cases where they will knock them down, because it will be redevelopment proposals. So actually there is a direct link there. There'll be plenty of brownfield sites where there's older stock, where house builders might want to come on and build houses to a national standard and wouldn't do so if there's local standards. So I think perhaps there is a bit more of a link. But I think one reads, certainly I would endorse that they should be read together.
Thank you.
So, final observations on this, because it's short, so I don't need to spend a very long time on it, but it clearly identifies principles. One can see that in the first paragraph, focusing on relevant principles. And it is short, but it's of real substance. And remind the court, the passage I went to earlier at page 11 in the supplementary bundle, that if the conclusion is that the potential effect of the policy is limited, the EPPS itself tells us that a lighter touch application is appropriate.
I thought you went a bit further than that in your skeleton, both in relation to this document and more certainly the EPPS in February 2024, when you said that the upshot of the reasoning was to take the case into the territory of section 19, subsection 2. The modelling shows that the benefit you get is relatively insignificant, so as not to justify basing the policy on higher standards, taking into account also that the FHS, in the view of the government, is compliant with the Climate Change, or will be compliant with the Climate Change Act in any event.
And I maintain that point.
Yes. So this is a slightly softer version of it, that even if it doesn't get to section 19.2, it's still a light touch.
Yeah, as I said, submitted my skills and argument, there's two aspects to proportionality. There's what you do, because I'm facing the criticism that this doesn't engage, doesn't look at alternative designs, let's go back to the drawing board. My submission doesn't need to.
But as Mr. Tromans also rightly says, you can't rely on section, I'm not saying that's this case, but one cannot rely on section 19.2 as a substitute for applying EPPS. You apply EPPS and then see whether the outcome is section 19.2.
Yeah, the section 92 in its terms relates to actions taken, and the EPPS talks about proportionality in both in terms of the assessment that's done, I suppose that's one kind of action, and then also the outcome of the assessment. So it might be that it's a fine debate that we need to get into, but section 19.2 is not limited in that sense. So my submission, section 19.2 does have some relevance to the nature of the assessment we want to carry out as well. But I don't need that because it's in the EPPS. And the duty is no more than what is in the EPPS in any event.
Can I just ask whether this October assessment or statement went to Baroness Penn? Because at paragraph 36 of Mr. Palmer's statement, he says GLUC wanted to publish as quickly as possible. It was agreed a submission would be sent with the background so she could, by Baroness Penn, review the matter. But we don't know what went, do we?
We know this didn't go. At this con then, that's the, there was, we don't have any evidence before us, I think a copy of the submission that went to her. There was a submission that went to her with the wording of the WMS, what was omitted. That's really why we're here.
No, I understand why we're here, but I just wondered what had actually gone to her. Do we know? Do we have the submission that was sent to her?
It's not until before the court. I had to check whether it was before the judge. I can't recall. But the point that we've always accepted is that it didn't include the October assessment. That was the omission we accept issue.
Yeah. Thank you.
You could forget this case for a moment just to think about the principles. You could have a policy which is being evolved and developed during a period when the duty is in force. And there might be a full assessment for the purposes of EPPS, the upshot of which says this is a section 19.2 case. We don't want to change our policy in those circumstances. Then subsequently, before the policy is finally adopted, there are changes to policy. But at that stage, no one does a further EPPS assessment because of those changes. And then a legal point is raised as to whether the court should intervene and grant relief because there's been a breach at that stage. If the minister in such a case was then to look at matters again, he or she would be entitled to take into account the earlier non-challenged, if that be the case, EPPS assessment, which came up with a section 19.2 conclusion, and then could focus presumably on the changes to the policy to see whether that altered the assessment. That would be, on the face of it, a logical approach.
Yes, I'd agree with that, and it's not this case.
No,
the October assessment was never a non-statutory assessment before
I
the
appreciate
came into
that.
effect. But I do perhaps draw the court's attention to footnote 19 of my skeleton argument, page 38 of the bundle.
Sorry, could you give the reference again?
Sorry, footnote 19, page 38
Of the...
of my skeleton articles of the core bundle.
Thank you.
There I say that one really has an ongoing duty of trying stages of policy making. But if you had a Section 19 compliant assessment earlier in the stage when the duty was in force, query whether you need to do that again in each and every stage. I think as long as it's done at the critical stages, that's enough.
Indeed, insofar as this case is concerned, the lighter touch point you make in paragraph 60 of your skeleton also referring to section 19.2.
And what do you say to Mr. Goodman's specific criticisms of the October assessment?
Insofar as it's said that it doesn't refer to environmental principles or assess policy against environmental principles, in my submission it does. Refers to those principles, focuses on impacts. In any event, the touchstone, if one likes it, what needs to be done here is the statement. We need to have regard to the statement. I put the court to the statement focusing on impacts. It clearly addresses in substance with those questions. Insofar as it said, and this was a point he raised perhaps more forcefully in the context of the February assessment, but it applies to the October assessment as well, about the splitting to and from, the conflation of the WMS with the FHS. That's just misconceived. They're intimately connected. So it was right for them to be both considered here. There is some authority on that in the Court of Appeal in the West Berkshire case, which was a PSED. That was a post facto PSED assessment. It was also a written ministerial statement. But in that case, that assessment had been relatively brief, I think it's fair to say. It might be worth just turning up that authority just towards the end of West Berks. West Berks is tab 16.
Thank you.
And the discussion, court's conclusions, start on para 80, page 319. Draw attention to this point. I think it is relevant to the October assessment, also the February assessment. One can see para 81, this is the assessment that was carried out. The issue in this case was a change in policy relating to affordable housing thresholds, effectively. And in the assessment itself, there was reference to government in other policies promoting the delivery of affordable housing. So it said, well, yes, changing the affordable housing thresholds will impact on the delivery of affordable housing, but look, here's some other policies that we're promoting that will boost affordable housing, and that's set out to inform the conclusion in that assessment that the impact will be minor. So that's the issue then that was raised in that case, was whether or not reference to those other policies is legitimate. And at para 83, you'll see that the court's conclusions on both the nature of the assessment and that point. Context. The context by reference to other policies of affordable housing. And then over the page at para 84. The court finds in the terms that are set up there that it is legitimate to have regard to other policies within the assessment.
Thank you.
I'd say in this case the position is even clearer. We're not talking about other policies in the same area, which would be relevant. We're talking about a closely aligned policy to which reference is made in the written ministerial statement itself. Unless there's anything else on the October assessment. As far as the February assessment is concerned, that's supplementary bundle 22 to 28. Many of the same points apply, so I can probably take it relatively briefly. So it's tab 3, supplementary bundle, page 22 and following. It's a thorough and staged assessment, but it's not based upon sort of new or totally new analysis. It effectively follows what was done in October. It just sets it out in a fuller staged approach, and of course has regard to the WMS as published at a point in time where Section 19 is in force. So Mr. Lieven criticised it for flitting between the WMS and the WMS and the FHS combined. I've made submissions on that. He did go to some particular examples of where he said this failing was manifest. I perhaps should just briefly touch on those. There were 3. The first one was on page 24, the middle of the page, where it says effects will occur cumulatively, thus gradually reducing emissions. That, he said, was, looking at the FHS only. But the problem with that submission is that the WMS and the FHS are closely aligned. The one's looking at policies that rely upon each other. The FHS for its smooth transition relies upon the WMS. So one can't just say, that's only looking at the FHS, given the support to the FHS the WMS is supposed to be providing. And similarly, one can't ignore the FHS if one's looking at the WMS. So in a way, it's the same point I've made before. I take the others relatively briefly. Next one's over the page. And it's under the heading integration. It was that first paragraph, first substantive paragraph on the page. At each stage of the policy, future home standard complemented by the WMS is intended in a way that makes the same point. It's right to say that one complements the other. You can see how that's can be any sensible objection to that. The third point that he went to was on page 26. And he took the first sentence of the paragraph to start prevention. Prevention is possible through policies we're proposing. Reduction of carbon emissions will have a positive net zero effect.
Sorry, can you give the page again, please?
26.
20, I misheard, sorry. 26. At the top paragraph, was it?
Yeah. Well, yes, positive net zero effect will be from the future home standard, among other things, but you have to read on. Goes on to say the WMS encourages local policies to be consistent with national standards, but still provides opportunity where those standards are found to be viable and not impact on housing delivery. So it's none of these examples, and one obviously has to read that the WMS read the assessment as a whole. But none of these examples in my submission really arguably disclose legal error. Ultimately, the question has to be: is the hypothetical lost opportunity cost from the WMS itself, is that recognised, addressed in this assessment? And it is. One can get that from the passage that's quoted by the judge, which is the passage between pages 23 and 24 in this bundle. Under the heading, is the environmental effect positive or negative?
And because of all the arguments we've had about Section 1, I'm now puzzled by what the paragraph means at 23. Is the environmental effect positive or negative? The last day and a half, we've been working on the assumption that the policy, the WMS, allows local authorities to go up to FHS, but they're discouraged from having things above the proposed FHS. And it says there is the potential for further environmental effects if LPAs set higher standards than those mandated by the building regulations. And one wonders whether that means the building regulations and also the proposed FHS regulations. Any potential benefits would be further reductions in carbon emissions occurring largely in the period between now and the time the FHS is implemented. That seems to be looking at gaps between now and the date when there'll be FHS, and the local authority will have filled that, or could have filled that with local standards. But that isn't what the MHS is about. The WMS is about allowing them to do that. I thought the problem after a day and a half was that they weren't, that the WMS doesn't allow them to go higher than the FHS standards, if you follow me. Or have I got it the wrong way round?
No, I think that is what's said to be the problem, and I think reading those two sentences together, those mandated by the building regulations, I think one has to understand that to make sense of the next sentence. I mean, building regulations existing or proposed, so that's the FHS.
Well, what does the next sentence? I mean, that's what I'd assume. Any potential would be further reductions in carbon emissions occurring largely in the period between now and the time the FHS is implemented.
So it's assessing, wrongly or rightly, but what it's assessing is what may be done over and above the FHS, and it's assessing that as being marginal, effectively.
But why is it only in the period between now and the time the FHS is implemented? Because you would have those benefits after the FHS is implemented if they're higher than the FHS, if you follow me. That's why I can't understand what this is driving at.
I think in fairness, it's just reflecting the fact that there's policy development when the FHS is implemented, that there'll be a new policy framework set out. So it's reflecting that position, and it's reflecting the intended transitional nature of the Written Ministerial Statement. The assessment, I think, and I can check this if I have an opportunity over lunch, but I think the assessment of marginal benefits probably does go beyond just the FHS implementation, but I'll have to check that.
So this is the February 24 one.
Yep.
And where do we go to now?
So I think we can probably park the wording of the February 2024 submission. In my submission, it is a rigorous assessment as is proportionate and appropriate to a particular policy that's in question. There's an alternative submission made by my late friend Mr. Goodman about apparent lack of fair-mindedness. Briefly on that, there's no reason to think that the assessment was not fair-minded, and the judge concluded, paragraph 46 of the judgment, that the assessment, this is the February-March exercise, had been done conscientiously in substance, rigour and with an open mind. My submission is not wrong to do so. Briefly, as far as Carlton Conway is concerned, that's a very different kind of case. It may be worth just quickly turning to Carlton Conway. You've got it in the authorities bundle, page 109 is where it starts. And it was, the error there was that the decision was wrongly taken by the planning officer rather than going to committee. That error was upheld. Then in the course of proceedings, one can see what the authority did to try and meet that, and it's a para 12 through to 14, pages 112 to 113.
Sorry, which paragraph? I was reading the headnote.
Paras 12 through to 14. And effectively, as you'll see, a sort of hypothetical exercise was done where a report was put to the committee that the court held should have heard the matter in the first place, seek their views. This is the quote under para 12, in the abstract, on whether the application would have been acceptable. and you'll see paragraph 14 that the officers recommended that they should confirm the decision. It's an unusual case. That was rejected as a get-out by Lord Justice Pill, and his reasoning for that is on page 114 to 115, paragraphs 24 and following. In particular, paragraph 27. But it's a case very much on its own facts. There was no hypothetical exercise here. And while one can see the justification given the exercise that happened there, and in a way subverting the planning application process by presenting something hypothetical to a planning committee, the judge was concerned in that context about what a member of the public who might expect to be involved in the planning process would have thought. So one gets the observation about fair-minded members of the public in that context.
Because here, if the wrong person had taken it, he tried to get another group to say, well, we'd have done the same thing, but here the minister should have taken it, she didn't, and the minister, the different one now, Mr. Rowley, does take it. That's
one distinction. The other one is that the terms in which the minister was asked was to consider openly whether to revisit the policy. No sort of sense of pressure, and the assessment that was done, I mean, we don't have the full assessment in this case, but the assessment that was done was, in my submission, an adequate and full assessment. So,
well, as I said, this case is being relied upon in a situation where it's assumed the court decides that subsequently the duty was complied with. And the question which arises is there scope for applying this principle if the court decides that as a matter of substance, Section 19 was subsequently respected?
In reality, rather than the hypothetical world of Carlton Conway.
I mean, if it wasn't, then you don't need Conway, etc. Whatever it's called, Carlton Conway.
I covered the point about, as far as concerns made about one day earlier, and the March minister was Mr. Rowley. Is relevant, as I've already submitted, that he was the minister also responsible for the non-statutory assessment in October. So this moves me on to consequences, and I think I can take this relatively briefly. There's a few strands by which the court, we invite the court not to take action and should not, in my submission, quite really, despite the acknowledged mistake. They are distinct, but there's clearly analytical overlap between the factors that go into them. Perhaps logically, especially in light of the judge's decision, substantial compliance is A1 synergy point. The first one. The second strand would be the court's inherent discretion, and note that it's the judge, paragraph 44, applied one of these. Not clear which one. I'd assumed it was discretion, but she may have just thought there was no substance in it either.
Which paragraph do you say?
Paragraph 44, I think. I'll just check I've got the right reference for the court. The bottom of 44, my lord.
Yeah.
Not appropriate to make declaration, my lord. But the judge is doing that using the non-statutory functions that she has. She's not applying Section 31.2a. So Section 31.2a, I think on this appeal, is a fallback, and we've raised it for that reason in the respondent's notice. So it's very much a fallback, and it may well be that the court doesn't need to add to the jurisprudence on Section 31.2a in this particular appeal.
Well, she's wrong in her judgment now, isn't she, in the light of this court? Well, no, there's another case where she was wrong. I mean, how does Section 31.2a help here? Because there was a breach. And I suppose all that says is we're not allowed to grant a remedy if the result would have been the same. But the problem is we don't know what would have been done in December. We do know that when she looked at it, when somebody else looked at it in March, it does seem to be inherent discretion. There's no point in granting a remedy here.
Well, section 31.2a, if I can jump to that and get it out of the way, in answer to your Lordship's question, we relied primarily on the Friends of the Earth case, relatively recent Friends of the Earth case, in relation to the National Adaptation Strategy on that point, and that one is in the Authorities Bundle, tab 26. The discussion that's relevant starts on page 769. And perhaps the key point is the conclusion. So this was a case where there hadn't been any kind of equality assessment done before the strategy was published, but there was one done later. So that's EQIA 1 and EQIA 2. At para 139, you'll see Miss Justice Chamberlain, I think's conclusions. Being that he finds the outcome of EQIA 2 shows that results are highly likely to be the same. There's no point, and he addresses the matter in terms of section 31, section 3D, rather than 2A, but same test. So if we get there, I say that applies equally in this case. As far as the other ways of getting to the same outcome, analytically different but other ways, the line of authority in Senagian A1 was addressed in your Lordship's judgment in...
Yeah, I'm just trying to go back to that 31A2. Was the outcome for the appellant, would the outcome for the appellant have been highly likely to have been substantially different, not be substantially different, if the conduct complained of had not occurred? So the conduct complained of here was the failure to comply with the duty in December 2023.
Yes.
Would the outcome have been, is it highly likely that the outcome would not have been substantially different, i.e. presumably that the same policy would have been adopted?
My suppose the answer to that is yes, and one to inform that conclusion can look at the February assessment. Mm-hmm. The question of if the conduct had not occurred anticipates the court thinking about, had there been due regard given by Baroness Penn in December, what the outcome would have been. In answer to
it's highly likely that it would not have been different.
Different from the one that came along in February.
In answering that question, the court looks at all the circumstances, not limited, and that includes the February assessment. So that's effectively the exercise that Miss Justice Chamberlain did in the Friends of the Earth case.
Yeah. Because there was discretion before section 31.2a was ever thought of, and if there'd been a breach of duty, it's quite common to say, well, we're not going to quash, or we're going to grant a declaration, or sometimes to say the judgment will speak for itself. We can't grant a remedy if the provisions of 31.2a apply, but we might never get there because we might not be minded to grant a remedy anyway, so maybe discretion first and then section 31.2 if we were minded to grant a remedy.
I certainly think on appeal that's the right approach in this case. Whether it would always be the right order, it may depend on the facts of the particular case, and that appears to have been the approach taken by the judge, because I did plead there's 1.2a before, I wish you didn't see it as necessary to consider that point. So the two inherent jurisdictions then of the court, which are distinct but overlap to some extent, are either the Senagi or A1 approach, and that was discussed in the context of the judicial review, statutory review proceedings in the Greenfields case.
Sorry, in the which case?
Greenfields.
Greenfield, yeah.
But there's no compliance here.
There wasn't. It's for the approach rather than the outcome. That I refer to that, and partly I rely upon the Greenfields case because it's an application of Synergy and A1 in the context of a judicial review challenge.
Yeah.
As the court will know, the Synergy itself, I think, was criminal law proceedings. A1 was sort of civil law proceeding, landlord-tenant type issues. But what Greenfields does is it confirms the relevance of Synergy and A1 analysis in the context of judicial review proceedings. Now, one could hypothetically ask, well, how does that differ from the court's inherent discretion in any event? It is analytically separate in my submission, but it clearly overlaps. And the questions, one can see, it's on page 851. That's where the judgment of Lord Briggs and Lord Sales in the A1 properties case is set out. There's two parts to it. There's the purpose of the requirement, so here that's section 19.
You need to be slightly careful because in Synergy and here there was a statutory obligation that something happens, i.e. that they publish the draft section 106 agreement on a register, and then the decision is the decision to grant planning permission. Here there's just one process. In the course of that decision-making process, they don't have regard to the environmental principles. But anyway,
I'll proceed. I mean, insofar as one doesn't need this line of authority, one gets the same from inherent discretion in any event, and there must be an overlap between them. But one's looking at two matters: the purpose of the statutory obligation and the facts of the case. And as the court could see towards the bottom of page 851, the question that arises is substantial compliance with the procedural rule. It's the appropriate way to look at it. So briefly, in this case, this isn't what was identified by the Supreme Court, Para 62, as a sort of bright line case. Section 19 is clearly not a bright line rule. Everything that follows must be quashed. So, in terms of the purpose, it's more nuanced than that. As I've already submitted, I do say it's possible to have due regard post-adoption. So one considers the facts, and one has to ask whether there's been overall, in the whole course of events, substantial compliance, and in my submission there has been, such that the admitted breach then isn't one that the court should be taking action on. The alternative point is the court's inherent discretion, and the best case for this.
So are you saying that there was substantial compliance here, such that no remedy should be granted? Is that your submission? Just so I fully understood it.
Yes.
One way of putting that on your case is to say the fact that there wasn't an assessment in December 2023 is not material, given the assessment in February.
Yes, and analytically, there is clearly...
It's a bit like your Section 31(2)A argument. If that assessment had existed in December, no reason to think it would have been any different.
But substantial compliance goes to whether or not the material time an obligation was complied with. The material time was December 2023. The obligation was to have regard to the EPSS. That was not complied with at all. So it's hard to see how there's substantial compliance with the obligation that had attained at the time she made the policy. That's the difficulty that I'm struggling with. You're back to, I know she committed a sin, but it wasn't really that much of a sin. It's like the housemaid's baby, it's really a small one. That's the problem. You seem always to want to come back to the fact that at the end of the day, that which happened was not unlawful, but it was, I think. Anyway, you say there was substantial compliance in December 2023.
Yes. The alternative point, which may have some more analytical simplicity at least, is of course discretion, and West Berkshire is the best authority for that. We already went to that authority in a slightly different context. It's more or less the same pages. It's tab 16, page 321. Fairly well known paragraph of paragraph 87.
Sorry, page
321.
Thank you.
So actually the discussion is paragraphs 86 and 87. But the conclusion is paragraph 87. You'll see the court's approach should not ordinarily be that of a disciplinarian, punishing for the sake of it. The focus should be on the adequacy and good faith of the later assessment, though the court's entitled to look at the overall circumstances in which that assessment was carried out. And I do say that an important part of the overall circumstances was the October assessment, which was done. So for all those reasons, round 1 should be dismissed.
Is there any authority on our approach to the review of the judge's exercise of her discretion?
I do cover this briefly. There's nothing in the bundle. I cover this briefly in my skeleton arguments, when I can lay my hands upon it. When I can find it, I cover it in a footnote to my skeleton argument.
Because she, whatever box she puts it in, she says that in the end, it's been corrected now, and the policy as it stands is okay. And she said it's not appropriate to make a declaration of unlawfulness in those circumstances.
Yeah. It's page 46, core bundle. It's footnote 31. So it's the sentence at the end of paragraph 70 at the top of that page, core bundle 46.
Paragraph 46 or page 46, sorry?
Page 46.
Page 46.
And it's the sentence at the top of the page, which is the end of paragraph 70. Court of Appeal should not lightly interfere with the exercise of a first instance judge's discretion. That's what's before the court. I don't think there's any issue taken with that basic proposition.
Yeah.
Oh, yes, that's the Carver BN reference that I saw in paragraph 72, and that's the one that's not to be followed now. Yeah.
We didn't put Carver BN into the bundle.
So we're now on to ground 2, are we?
Yes. So I may go over lunch, but I think that may be helpful just for clarifying a couple of points in relation to ground 2 that the court's asked. So I'll make some headway and then stop at an appropriate time. There's two parts of the written pleadings that are relevant to ground 2. There's my skeleton, of course, in paragraph 77 and following. There's also, as your lordships I hope have seen, my response to the Essex Planning Officers Association submissions, which are core bundle tab 23, page 306. That's right at the end of the core bundle. The claim that we face is effectively one of frustration of statutory purpose. As I say in my skeleton argument, the correct lens to look at that is the Supreme Court's judgment in A, because we're looking at the lawfulness of policy. But in any event, the first question must be the terms of the statute, its purpose and meaning. So there's an issue of interpretation, and ground 2 appears to stand or fall on that issue of interpretation. In my submission, it falls. I shouldn't say even if it stands, I do make some other points as to why it should fall anyway. But, it certainly falls on the issue of interpretation. So we agree that the purpose of section 1, and that's in the statute bundle called CNET already, statute bundle tab 2, page 27. The purpose of section 1 is clearly to facilitate the inclusion of policies for energy use and energy efficiency in local development plans. And that's in the context of the desire to take action on climate change. This was 2008, it was a year where there was a lot of statutory activity on climate change. The question is how the provisions are designed to do that. And in my submission, there is no need for reference to Hansard. I'll come back to that. Given that the appellant now accepts, as I understood Mr. Goodman's submissions yesterday, that section 1(1)(c) is constrained. And it's constrained in two ways, which I'll set up briefly, but I think the court's picked up. Firstly, by the definitional terms, i.e. the definition of energy efficiency standards and energy requirements in subsection 2. That tells us that energy efficiency standards means standards set out or referred to in regulations, or set out or endorsed in national policies. So there has to be a level of endorsement by the effectively by the Secretary of State, and it means that the operation of section 1(1)(c) is contingent upon the wider policy context at the time of the policy being made by the local planning authority, and as I've already covered, at the time of this act coming into effect, the relevant policy framework or standards framework included the Code for Sustainable Homes. The second way in which it's constrained is subsection 5, a simpler, broader provision, because that applies to all of subsection 1, that policies must not be inconsistent with relevant national policies. Or, I should say, subsection 6, same provision in relation to Wales. Without going beyond the wording of the statute, it appears plain that the intention in the drafting is to ensure national consistency in the application of higher standards in local plan policies. So that policies may use this provision to exceed building regulations if they need to go further, they may use it. But only if they're going to use this within a recognised national framework. And there's a contemporaneous exposition, sorry, not contemporaneous, there's a non-contemporaneous exposition of this, but nonetheless helpful to take the court to, in the supplementary bundle, page 130. So one gets a useful description of what was done here. So this is the document that starts at tab 23. It's an impact assessment for the then Housing Standards Review. And the relevant paragraphs on page 130 at the top, paragraphs 22 and 23. Just ask the court to look at those. You see, it's a description of what was happening at the time of the creation of the Code for Sustainable Homes. I draw particular attention to the word combination, 23. It's the combination of the Code and the Planning and Energy Act that allowed local planning authorities to set standards. So the simple point is that section 11C, as I think I stated earlier, depends for its application on the regulatory and policy context in place at the time. And insofar as the challenge I'm faced today with, the short response, if I'm right about that, is that WMS obviously doesn't cut across that. If anything, as the court's indicated, the problem that might be said with the WMS is it goes further.
So I don't understand. Doesn't cut across, but goes further. What do you mean?
Well, it doesn't cut across it, is the key point.
Yeah.
The question that my Lord raised with me this morning about whether section 11C of the planning area is the only way in which energy efficiency policies can be included in local plans. If that is, then the question, if I understood it correctly, was then where within the, looking at the WMS, where within that does one find the approved standard beyond which you can go above the FHS? I think that, if I understood correctly, that's the question. And I don't have an answer to that immediately.
No. If it has to be an approved national policy guidance or regulation, policy guidance saying you can use draft, not yet implemented standards, is the thing that allows local authorities to use the draft standards. So it goes further in the sense that it permits not just fixed policies, but the policy allows draft standards, was the way I was thinking of it.
Yeah. So in any event, I could stop there because it's clear on that, and in my submission, that correct interpretation, that the policy does not fundamentally frustrate or empty of content in an unlawful way this statutory provision. It's consistent with and enabling of.
But another bit of the policy does appear to be supposing that something could happen, and it is discouraging it from happening, and that may not be enough for the reasons to do with A. And what I'm puzzled at, or what I'm puzzled about, is that last bit of 304, the policy, which seems to be talking about something that's the local energy standard, quite divorced from anything in national policy guidance. It appears to assume that such a thing exists, and then it purports to limit it. And Mr. Goodman may have got the wrong section. It may not be contrary to section 1, but he may have a point about it being contrary to some other section, although we haven't, ironically, yet been taken to any other section. But that's the problem, is the last part of 304 does appear to be restricting something.
I had a note to sort of to pick up this point. It's probably best if I pick it up at lunch and respond, but just so I can be clear as to your Lordship's question on 304.
Yeah.
This is in the paragraph, the improvements in standards already in force.
Yes, it's the sentence beginning, any planning policies that propose local energy efficiency standards for buildings that go beyond current or planned building regulations. Now that's current or planned FHS building regulations.
Yes.
But what local energy efficiency standards that are not national ones exist that they can use? Are there other ones?
As I understand it, I don't know if this is wrong, this is directed at policy making in local plans. So when it says any planning policies that propose local energy efficiency standards, it's not talking about national ones, it's talking about what local planning authorities put forward.
That's my...
Because this is being formulated in the context of section 1 of the 2008 Act, amongst other things.
I think that was the question. That's a way to the question. My response, I think, to that is it's not referring to a specific energy efficiency standard. It's referring to any variety of potential local energy efficiency standards. But if I understood correctly, the bite of my Lord Justice Lewis's question was, how does that fit the section 11C, read together with section 12?
Yes. Well, section 11C doesn't allow local energy policies in the sense of something that's divorced from a national guidance or policy. So if it's talking about something else, and that power exists, then that part of the paragraph is restricting that as yet unidentified power. So the ground of claim, the ground of appeal shouldn't have been this written ministerial statement is in conflict with section 1. It arguably is not, for the reasons you've given. It might be, it may not be. But it is in conflict with something else, because it does appear to be saying there's a power somewhere to fix standards that do go beyond those in the FHS or the building regulations. And if they're doing that, that should be discouraged.
I think I will reflect on this further over lunch, but I think the point boils down to the legal effect of section 11C to a large degree. If section 11C exhausts the possibility, then there is no other power. If we assume that it does not, which is the assumption I was making earlier, although it's not an issue in this case on which there's been pleadings or consideration, if we assume it does not, and there is another source for the power, that source for the power is found primarily in the planning acts.
Right.
That was a point that was raised by the claimant, now appellant, first instance. You may recall there were 3 limbs to it, I think, but one of them was this was contrary to the section 19, I think, ability of local planning authorities to make policy to combat climate change. We saw that section 19(1)(a). But that would be
Section 19(1)(a) of
the, I apologise, of the Planning and Policy Practice Act 2004. You've got that. Authorities, page 15. So that, if we assume that in favour of the appellant, and that's being cut down, that's, in my submission, the answer to that, well, it's entirely normal for there to be national policy that sets restrictions or tries to control standards that are set in local plans. I mean, the NPPF is full of examples of that. So it's certainly not unlawful. And it may, of course, it's intended to have some control and restriction on policies. That's obvious. Doesn't mean it's unlawful. The focus of the argument on appeal takes us to section 1, and particularly section 11C of the Planning and Energy Act, which I think perhaps one can appreciate from the debate that we've had in court why the judge went to Hansel. Whether she needed to or not is another question. I will reflect on it further if I have anything more to add. But it's probably an appropriate time to take a break now. I was going to move on and discuss Hansel briefly, and I don't have a lot left, so I hopefully won't take us very much past 2.
Thank you very much. So a sort of guesstimate for your submissions this afternoon?
Less than half an hour, probably considerably less.
Thank you. And Mr. Goodman, just so that we have some idea, no one's going to hold you to it, just a guesstimate.
15 minutes.
Okay, thank you. Thank you all very much indeed for all your help. We'll see you at 2 o'clock.
Why is it